Welcome to Public Forum, a community outreach program produced at North Idaho College on the shores of Lake Coeur d'Alene. Featuring guests from around the globe addressing a wide variety of subjects, Public Forum serves to educate and enlighten. Please join host and moderator, political scientist Tony Stewart, in welcoming today's guest.
Today we are continuing our long series on Hot Talk, Passionate Debate for New Age. On today's program and next week, our subtopic will be privacy. Our distinguished guest today will talk about privacy and the right of the public to know certain things, and his thesis is basically that, more so than the guest next week, that privacy sometimes must yield to the right for the public to know, particularly after the September 11th crime in 2001. I welcome to the program Jeff Jacoby, a well-known name on the East Coast. He has been an op-ed columnist for the Boston Globe since February 1994. Our distinguished guest is a conservative voice to balance a very famous liberal roster of commentators at the Globe. He was hired there to express a very conservative philosophy that he articulates very well. The Boston Phoenix has described our guest as the region's preeminent spokesman for a conservative nation. He is well educated. Our guest is a graduate of George Washington University in 1979. He also holds a doctorate in jurisprudence from Boston University Law School that he received in 1983. From 1985 to 1987, he was an assistant to Dr. John Silber, the then president of Boston University, who received lots of attention as the president of that university. Mr. Jacoby, thank you for coming to Idaho, and thank you for being on our program and speaking at our college.
Great pleasure. Thanks for having me.
And I'm so pleased to have our regular panelist, Janelle Burke, an attorney in the state of Idaho, and she will commence the questioning with Mr. Jacoby.
Thank you very much for coming. It's a pleasure, and we hope you enjoy your stay while you're here.
Thank you.
I want to ask the first question about the right to privacy, and so that we kind of lay a foundation for what our discussion is going to be about. We're basically talking about an individual's right to privacy versus the government's right to pry into individuals' affairs, some people would say, or the government's right to know certain information about a person. And this can take the form of a national ID. It could take the form of knowing where you're going, when you're going, following your travel, and so forth. A great number of issues there. So can you please talk a little bit about what you consider to be, as a general thesis, the amount of information that the government should be entitled to? That's a very broad question.
It's a broad question, and it's one that has no fixed answer. Obviously, privacy is something that all Americans care about. Privacy is built in as a right into the Constitution, although the word itself doesn't appear. The Bill of Rights, the Fourth Amendment, which guarantees citizens the right to be free from unreasonable searches and seizures by the government, clearly attaches a great value to privacy. But the very fact that there's a word like unreasonable in that statute suggests that there's a balance to be made, and that balance, where that balance point is, will shift from time to time. Not only when it comes to privacy, I'd say when it comes to civil liberties in general. We've got a tradition in this country, a history of leaning on the side of greater civil liberty, a more small L liberal approach when times are good and things are safe, and then retrenching somewhat in wartime or in times of danger. I was reading on the plane, I had a long couple of flights coming out here today from Boston, and I was reading about the Lincoln administration and the thousands of people, something like 12,000 citizens were arrested during the Lincoln administration, during the Civil War, Northerners who were sympathetic to the South or who were opposed to war. The anti-war activists, the Michael Moores of their time, rounded up and held in prison without charges. What the Bush administration today might call enemy combatants or unlawful combatants. We get exercised today because 2 or 3 or 4 American citizens may find themselves in that position. Here was Abraham Lincoln throwing 12,000 people into prison. We would regard it today as shocking and unthinkable, and maybe by our standards such a thing could never happen. And yet, if the Union hadn't won that war, slavery would still exist, and the United States of America probably wouldn't. So there's always a tension. I think post 9/11, recognizing that we're in an international war against an enemy that will stop at nothing, it's reasonable to say that individuals' privacy expectations come down a little bit and defer a little bit more in the interest of national security than might have been the case 5 years ago. And as the war, comes to what we all hope will be a successful conclusion, as safety becomes more assured, there will be room for greater amounts of privacy and civil liberty.
I want to expand on that because you just built the bridge for my question. A very, very famous case that addresses this issue is Shink versus the United States in the early part of the 20th century, near the end of World War I. And I think of that in the terms of the Patriot Act and what happened on 9/11. In your correspondence to me, you've been very, very clear and articulate on making a statement that you certainly support privacy. And the court has talked about in the 4th, 9th, and 14th Amendment, but you also indicated in that correspondence that 9/11 has changed where you draw the line. But in the Shink case, the court said because of our struggle for survival in World War I, would it also apply to World War II, that in time of a great crisis or war, that free speech and press, and therefore privacy to some extent, can be more narrow. And that there are certain things you can't do in an all-out war that is of no consequences, the court said, in time of peace. So would you say that the Shink case would be applicable today in relation to the Patriot Act and 9/11?
You said in the introduction that I graduated from law school, but I confess I've forgotten what the story was in the Shink case. So you'll have to remind me. What were the facts?
There were some. Excuse me for not doing so. There were a group of men who distributed 15,000 leaflets to other young men saying you should not participate in World War I, and they were tried under the Espionage Act. And they argued that they were being denied such things as free speech and free press. And then we could also, I would extend it to talk about the issue of privacy, but the court said no, we uphold that guilty verdict because those pamphlets would not be of that kind of consequence in time of peace, but the government has more power in time of crisis. And I'm just trying to relay that back to what you're talking about.
I think that's a good illustration of how far we have moved in the direction of greater freedom, greater liberty, more expansive rights for individuals. Hard to imagine that today anybody could get arrested for distributing a pamphlet no matter what it said. Even if it came out against the war, even if it urged people to not re-up for the National Guard or to oppose the war in Iraq or to oppose the Bush administration. I think it's virtually impossible for us to imagine people getting arrested today on those grounds. So we have pushed the boundaries of the freedom that we take for granted, that that we build in right at the foundation, pretty wide open. But for example, when we talk about encroaching on privacy expectations today, one great infamous illustration that critics of the administration point to is Section 215 of the Patriot Act. This is the one that broadens the government's powers to get, with court approval, documents, tangible things is what the statute actually says. Business records, but for some reason, actually it's not for some reason, very calculatedly, the American Library Association seized on that and said this puts everybody's library records at risk, so that you can come into a public library and do things on the internet through the computer terminal, or take out books or research certain information, and the government would then have a right to come and look at those records. And they've managed very effectively to build this up into a great illustration of how Big Brother is breathing hot and heavy down our backs, and the freedom as we know it in America is coming to an end. To which I would say, number one, the government doesn't have interest in what dirty book somebody's looking up in the library. And in fact, at least the last I heard, Section 215 hadn't even been invoked yet in the years since it was passed. But number two, there have indeed been cases, even some that we will remember, in which what a patron did in a library was very relevant to solving an important case. For example, Ted Kaczynski, the Unabomber, was tracked down in part through library records. Andrew Cunanan, the murderer of Gianni Versace, the Italian designer who was murdered in, I think it was California. Florida was tracked down in part through library records. If it were the case that a Mohammed Atta, one of the 9/11 hijackers, were going into a public library and using, let's just say, I'm just spinning this out here, using a Hotmail email account, which anybody can get for free, and accessing his email to communicate with other conspirators through a computer terminal in a public library, and they were using that terminal and that Hotmail account to plan some horrible attack. Does anybody really think that the government is encroaching outrageously or unreasonably on privacy expectations if it expresses an interest in getting those records? It seems to me that it's reasonable to say that in a circumstance like that, you would want the government to be able to get hold of it. So I don't think that we're back in the Shink days. I don't think anybody's going to prison because they're distributing leaflets opposing something that the government or the administration supports. But I do think we're in a war. The enemy, as we know, isn't just overseas. The enemy is here as well. And, there are certain things that should not be quite as elaborately protected from the government's ability to get a look at it, with appropriate precautions and appropriate safeguards, like having to get a court order first, as would have been the case earlier. And I suspect from the fact that, for example, the Patriot Act, which in the 2004 campaign was being whipped up as a great stick with which to beat the Republicans, at first quickly died away once the Democratic candidates in the primary realized this issue just was not cutting with the public. What I draw from that is that, by and large, Americans understand this is wartime, and in wartime, you make arrangements, you make adjustments.
Mr. Jacoby, I think that you're very correct to say that the example of the leaflets in the Shink case, that would not happen now. That, in other words, our freedoms then have been expanded. But I guess the only thing I'm saying that supports your argument is that the Shink case, the real theme here is that the court invites the U.S. government, whether it's dealing with privacy or free speech, to put some more limits on it when we are in a very great crisis.
As I say, the Fourth Amendment, Ninth Amendment, other amendments to the Constitution make it clear that privacy matters. But before anything else in the Constitution is the preamble, and one of the primary reasons for which the Constitution was adopted was to provide for the common defense. And that has to come first. If the common defense goes, if the country is endangered, all of our civil liberties won't amount to much. So I think that principle holds. At the same time, I got to say, I realize this whole discussion is in the context of debates at North Idaho College, and there are people and organizations like the American Civil Liberties Union that argue very strongly on the other side, and I'm glad that they do. I'm glad that I live in a country where the government may be pushing for more ability to look into my papers, and that there are people on the other side pushing back just as hard. I like knowing that there's that tension.
It creates a balance.
Exactly. It creates a balance, and it prevents either side from going too far for too long at any point.
Thank you. Janelle Burke.
The question in this round is going to have to do with modern technology. Obviously, today we can collect large amounts of information, and we can store that information. What kinds of checks and balances would you put on the government being able to store all that information? It might be useful right now for dealing with terrorists, but at some future time, it's still out there because of the modern technology that's developed.
Well, I should preface any answer I give by telling you that I'm very much a 20th century, not a 21st century guy.
Okay.
I don't even own a cell phone, so for me to talk about technology is to really dig deep into my reservoirs of ignorance and hold forth.
It's nice to meet someone who does not have a cellular phone.
But we can certainly collect and store information that we couldn't collect at any time in the
Right,
past.
and my sense is that there's a lot more alarmism about personal information being out there and being accessible than is really justified. Every financial institution that we have anything to do with, every 6 months seems to send a piece of mail about their privacy policy, and how if you want to, you can write to them and opt out of their sharing information about you with anybody else. Maybe there are people who do that. Maybe you guys do it. I've never actually met anybody who goes to the trouble of writing to the bank or the credit card company, do you really? And say, please don't share my name, address, or information with anybody else. The vast majority of consumers don't do that and don't worry about it. And I think really that's probably a good thing. Yes, there can be something like, what do they call it? Identity theft, where a criminal gets hold of your identity or your social security number and uses it for his own purposes. But by and large, increasingly, I think society depends on that information being available in databases. The government's already got access to so much through Social Security records, through IRS records. Reasonable precautions, I think, by definition, reasonable precautions are reasonable. And if there's a way to say the government can have access to certain information, but at a date certain in the future that access has to disappear, I guess I'm open to considering that, to debating that. But I'm not sure what it is that we would want the government to be able, if need be, to get hold about us today that we wouldn't want it to be able to get hold of down the road. You're not talking about there's probable cause to suspect you or me of a crime, in which case we would always want it to be able to get access to information to prevent the crime or to prosecute the crime. But information that it would have access to on an ongoing basis, on a standing basis, whether it's the Social Security number or the name or the address or the date of birth or the earnings history or all these other things, I think we've already given up so much of that. We assume that the government has access to it. I'm hard pressed to come up with an example of something in that category that we would say, all right, today we'll let the feds dip into it if they need it. But 2 years down the road and thereafter, it can't do it unless it's somehow reauthorized. No good example comes to mind.
We had also two people here earlier on this program, different programs dealing with the Patriot Act, and they were very articulate on both sides. Another issue that has come up in relation to privacy has to do with the Patriot Act, which was, of course, a product of the final result of what happened on 9/11, although there was some work already being done in that area.
Quite a lot, actually, was already on the shelf waiting to be enacted.
Right, and that increased the urgency to do it. One area has to deal with, I don't know exactly what the term is, but to seek and to peek. And you still have to have a search warrant, but you
delayed notification.
Delayed notification. I want to get your reaction to that in relation to the issue of privacy, because it too has been debated from both sides.
Right. Clearly a big Fourth Amendment issue.
Yes.
And the question is, if the government gets a warrant to search your home or search your business premises, or to put a wiretap on your telephone, obviously that implicates your privacy interests. We don't allow the government to do that unless it first gets a court order, a warrant, or in some cases a subpoena from a grand jury. But the question is, when do you have to be notified that the government is going after this information? And the rule in general has been you're supposed to be notified in advance, but if the government can show that there's a danger of life, somebody may get killed if you find out in advance. For example, you're a suspected mafia hitman, and you find out, you're notified by the government that it's going to come and search your records, and you know that only Jeff Jacoby could have supplied that information to the government. That may put my life in danger if you're told in advance, or it may lead to the danger of evidence being destroyed or a material witness fleeing. So in other circumstances, organized crime prosecutions, drug prosecutions, I think pornography, child pornography cases, the statutes have allowed this delayed notification. Within a certain period of time after the search, the person whose information or property or belongings was searched has to be notified. So what the Patriot Act did was essentially expand that authority and apply it as well to terrorist cases. Even more, I would say, that in some of these others, you can see the reasonableness of saying, we don't want the government to be forced to tip its hand in advance if it's going after a terrorist, somebody who may be responsible, for planning something that will cause the death of hundreds or thousands of people. That doesn't seem unreasonable. And again, since in all of these cases there has to be court authority first, that's a check and balance that I think makes it reasonable. In all of these cases, with all of these circumstances, we can always imagine officials with bad faith not behaving reasonably, not doing what they ought to be doing. We can imagine a corrupt judge or a prosecutor who bypasses the court or provides false information to the court. All of this depends really on reasonable people being in power and reasonable authorities exercising the power. our whole system really kind of depends on a general balance of reasonableness. If we've come to a position in which there's such faithlessness on the part of public officials that we can't count on them to observe the law as it's written, then we've got a much bigger problem than what the Patriot Act may or may not say. But I don't think, by and large, I don't think we are in that position. And we've built so many checks and balances into our system at all government levels. For the most part, the balance seems to hold.
James Madison had a lot to do with that, contributing to the checks and balances a long time ago. Janelle Berg.
Following up on what you say, indeed, it does require that reasonableness. And perhaps what some people are afraid of is that at some point there may be the unreasonableness that would then have access to their private records and so forth. But my question will be to have you comment how what is maybe being gained today in information to combat terrorism might sometime in the future be used for other circumstances. So let's just talk about some areas that people talk. There's a lot of controversy about in the news media. One area being air travel searches, privacy in air travel searches. You might have a comment about that. Another might be national ID cards. Should we have a card that would nationally identify you? Should you be able to travel by air with your national ID card because you're an approved individual? And then a third area, private behavior, what people do in the privacy of their own homes. So let's start with air travel.
Tony introduced me as a conservative, and people might get the sense out there that I'm Genghis Khan's modern incarnation. But
that was not intended.
But the truth is that my conservatism has a great libertarian streak in it as well.
And that's often the case.
Right. Yes. There's a kind of tension in modern conservative thought between traditionalists and libertarians, right. And many of us have a foot in both camps. And certainly the kinds of things that you mentioned, they resonate with me.
And in the rugged Mountain West, you'll find that.
I don't doubt it. That's right. And as somebody who flies, with some frequency, I'll tell you just to take that example, I bristle every time I have to take off my shoes to go through, that blankety blank security thing. And I think this is so preposterous. The idea that these sometimes very long lines and all this inconvenience, and take everything metal out of your pockets and take off your jacket and take off your coat and take off your shoes and do all the idea that this is keeping us safer, it seems to me, is just preposterous. It's not a question of my civil liberties being invaded, and it's not a question of the government grabbing hold of a power that it's going to exploit even more unreasonably in the future. It's that I think it's just foolish. We're not going to make ourselves safer by making people take off their shoes. In fact, just to expand on this for a second, we go through the shoe business because of Richard Reed. He was the so-called shoe bomber, flying to Boston from Paris, and he had rigged shoes. And that was discovered, and fortunately he wasn't able to blow up his plane by doing whatever he was going to do with the explosives in his shoes. And ever since then, we all have to take our shoes off when we fly. What if Richard Reed had a rigged wallet or a rigged pair of eyeglasses? Then everybody who wears eyeglasses would have to take those off now, and nobody would even be thinking about shoes. In a column once I wrote, what if on 9/11, instead of using airliners as weapons, the hijackers, the terrorists, had gone into crowded movie theaters and blown themselves up and everybody in the theater, in 4 separate theaters? Then to this day, we would all have to make arrangements 2 hours in advance to go see a movie. You'd stand in long lines, go through metal detectors, but meanwhile you'd be able to get on an airplane 10 minutes before your flight, just breeze on through and nobody would think about it. So it's all very reactive. And I have trouble with letting the notion take root that we make ourselves safer against international terrorism by reacting to the last tactic that the terrorists happen to use. That's one reason, and I know this is not what we're debating today, it's one reason why I'm such a strong supporter of the war. I think the way you defeat terrorism is to go to where the terrorists are hatched and to deal with the problem over there. As far as the government getting hold of powers today and hanging on to them beyond the point where it becomes reasonable, that's why we have elections. And that's why we debate these things in the context of election campaigns. And if it had been the case, for example, last year, that the more John Kerry talked about the Patriot Act, the more that issue really caught fire. the more opinion polls showed that that was really something the public was outraged by, then the more likely I think it would be that when a number of those provisions come up for renewal at the end of this year, that they wouldn't be renewed. The fact that this was brought up in the political context and the public seemed to indicate that it's mostly okay with it makes me think that when it comes up at the end of this year, it's going to be renewed. So, I put my faith in democracy and in the political system, and in the fact that politicians will always be trying to find what it is that's got the public exercised, and then we go to the polls, and we decide a lot of our questions that way, and that's how we figure out when things need to be fundamentally reoriented.
What you're here to talk about is privacy. It's fascinating that for whatever reason that one word was left out of the Constitution, but I was impressed with your comment about the Fourth Amendment, that if one had no right to privacy, then how can any search be unreasonable?
Right.
So it must have the privacy. But would you just talk in the short time we have left about, there was a lot of genius in the writing of the Bill of Rights and other things, but the Ninth Amendment certainly indicates that brilliance by saying if we forgot anything, it's here. And the courts always, they've used the Ninth Amendment. I'm thinking of the case from Connecticut, the Griswold case on dealing with contraceptives and all, and saying that it's in the Ninth Amendment. You have a couple has a right to privacy. Very quickly, isn't it interesting how that is used without the word being there?
I'd be interested to know. We'd have to ask a linguistic historian whether the word privacy was as common in the late 18th century as it is today. Remember, though, the Bill of Rights, to a certain extent, was forced into the Constitution after the Constitution was drafted. There was a great debate in this country between the Federalists and the Anti-Federalists. The Anti-Federalist position came down to, in the end, we're not going to support this Constitution unless you put in writing that people are guaranteed certain rights. One of those was then, the Fourth Amendment. I think privacy maybe was regarded as too broad a concept. Protection against unreasonable searches and seizures was something specific, and I think they were looking to home it in, make the point clearly, and not leave it open to be widely misconstrued or too broadly construed, in years down the road.
I've never asked that question before, and that was a fascinating answer. That on the program, we've been doing this for 33 years, and we keep having things we've never had before. Thank you very much, Jeff Jacoby. It's been great having you on the program,
Thanks so much.
And thank you for the generosity of your time. Ladies and gentlemen, please join us again next week, and we will continue our discussion. And our guest next week will have a more restrictive role for government in that position on privacy. Until then, please have a good week. I am Tony Stewart.
Recorded on the campus of North Idaho College, Public Forum is the longest-running in-house college production on PBS. Each episode is pre-recorded live and is an educational outreach from North Idaho College. Please join us at this same time next week for another edition of Public Forum on this public television station.